So what I'm going to be doing today is talking about guardianship reform. And when I'm talking about guardianship reform, what I'm doing is talking about reforming the process by which courts appoint somebody to make decisions for someone the court has found can't make those decisions for themselves. And I'm going to use the term guardianship to refer to both guardianship and conservatorship, recognizing that terminology does vary across our states. So I'll start today by talking a little bit about the paradox of guardianship, how although it's designed to be a protective arrangement, it can sometimes be a vehicle for exploitation. Then I'm going to talk about what it's going to take to make guardianship truly a protective arrangement. I'm going to overview some of the key law reform efforts to date. And then I'm going to talk about why I think the next frontier for reform has to be court reform and what that might look like going forward. So, when we're talking about the paradox of guardianship, I think it's important to recognize that guardianship can provide valuable protection for some individuals. So, imagine we have an individual who has a chronic illness, but who cannot understand the nature of that illness, even with substantial support, technological assistance, supported decision making, and the like, who has never done the type of advanced planning that might have appointed a surrogate to make decisions for them and can't provide informed consent to treatment or related decisions. It may, in fact, be the best approach for a court to go in and appoint a guardian. And yet, guardianship can lead to new forms of abuse, new power and control dynamics, new opportunities for exploitation and neglect. We know that a subset of guardians will exploit the people whom they're appointed to protect. And that may be deliberate. It may be more on the negligent type, charging, for example, unreasonable fees to people. We know that guardianship can isolate individuals, that a common approach guardians will take in providing care is to institutionalize, and that in most states, guardians can restrict a person's access to friends and family with virtually no limits. And even without bad behavior on the part of a guardian, guardianship itself can create stigma and trauma as individuals commonly lose the right to make all or nearly all decisions for themselves. So let's drill down a minute and talk about, sorry, we are missing a slide here. Okay. We are missing a slide. Fabulous. So we're going to talk about some of the key problems with the guardianship system. So one problem with the guardianship system is that some people are subject to guardianship who really shouldn't be. Right? They have needs that could be met by less restrictive alternatives. Maybe they could have always been met by less restrictive alternatives, or maybe today they can be. Second, we know that most people subject to guardianship are subject to plenary guardianship. That means that they're getting stripped of every single right the state can strip them of under state law. Whereas most guardianship should be limited, right? Because even people with very, very substantial cognitive disabilities can probably make a choice about something. Not everyone, but most, right? What to wear, who to see, whether I want to go to church. Right? Another problem is that some guardians' actions are harmful. We know that a subset of guardians, unfortunately, do act in ways that violate the human rights and the dignity of those they're designed to protect. Sometimes that's because they don't really understand their role, to be fair, right? Most guardians are lay people, and the law often doesn't give them the level of clarity they really need about what their role is. And finally, currently, we have systems that exacerbate many of these problems. For example, under current law in many states, it's easier for a person to seek and a court to appoint a full guardian over a limited one. Okay, so let's talk about some key law reform approaches to date. Broad brush. One group of law reform approaches we see in this space are approaches to create and encourage less restrictive alternatives, right? That may mean limited guardianship. So starting, a little history, Starting in 1976 in Idaho, we had our first state statutes authorizing limited guardianship. By 1987, 40 states had limited guardianship. Today, all do. So that's one reform. Single transaction orders, another reform. Maybe the person doesn't need ongoing monitoring. They just need someone with authority to do this one thing, right? Single transaction order in lieu of guardianship. Supported decision-making, which you've heard a lot about today, another alternative to guardianship. Another set of reforms we see in this space is adoption of rules that require guardians to do things we think are good, right? Encourage good behavior. So what might that look like? Well, we have a big push to person-centered planning and requiring guardians to have plans. Okay, you've been appointed by a court for this person. What are you going to actually do? Now, that's critical not only to help the guardian think through what is right for this person, knowing what I know about them, right? But also for the court to monitor it, because it's very hard. Any of you ever graded? Right? Very hard to know whether someone's doing a good job on something unless you know what their assignment was in the first place. Okay, another approach here is the use of substituted judgment standards as opposed to the more paternalistic best interest approach. Then we have a set of law reforms in this space that are designed to punish or discourage bad behavior. So what might that look like? Well, we've seen a big push and an appropriate push for limiting fees. Right? If I'm appointed as a guardian, do I charge my hourly fee as an attorney for going shopping? Increasingly, we recognize that would be abusive, right? If I should choose to go shopping for the person I'm appointed for, fine, and I can charge fees for that, but what's the market rate for that? I can assure you it's not my hourly fee. And then looking at increased penalties for guardians who run amok. So when we are thinking about these reforms, you might think, where could I find a one-stop shop to get all of them? And the good news is there is a one-stop shop for all of these things, and it's called the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. Isn't that sexy? Like it just slides off your tongue. We call it UGCOPA. But what it does is it combines all these best practice rules into a single law. Full disclosure, I served as the reporter for this law. It was about a 4-year process. We brought together national stakeholders, disability rights groups, family groups, aging groups, attorneys, judges, you name it. We all came together, and it's amazing if you actually get people in the room and talk about not just what are the problems, but how could we fix them, you can get consensus. It's a beautiful, beautiful thing. So this act has now been recommended by all the major groups, by the 4th National Guardianship Summit, the U.S. Special Senate Committee on Aging, the ABA, you name it. For those of you whose eyesight's better than mine, you may note that to date only 2 states have fully adopted. Maine at one end of the country and Washington at the other. And we have partial adoption working through some other states. That slow adoption in large part reflects court resistance and a lack of lobbying on the part of people who might find themselves subject to guardianship, right? Just a highlight of some of the, what I might call the gems in the Uniform Act as we're thinking about what this looks like in terms of law reform. Key reforms in this act include a limited basis for appointment. Under the Uniform Act, you may not appoint a guardian if supported decision-making would meet the person's needs. Full stop, not legal. It enables limited orders, not just limited single transaction orders for finances, but also for healthcare decisions, which is something most states don't have. So again, getting that protection without that ongoing restriction of decision-making rights. Expanding procedural rights for people subject to guardianship or subject to a guardianship petition is huge. The act requires guardianship plans. It has enhanced monitoring. And one provision which is particularly delightful in my opinion is that it recognizes that most people have, in addition to the court, people in their lives would be quite happy to pay attention to what their guardian is doing. And so it makes it a default for courts to grant family members of the person of subject to guardianship the right to notice of certain major things in the person's life. Now, the court can choose not to do it, but it makes it the default so that families can serve as eyes and ears for the court. It creates an informal grievance procedure as well. That's super important because you know what people subject to guardianship often don't have? A law degree, a free attorney, and ample amounts of time to learn court process. Same for their family members. So creating a way that lay people can notify the court of problems they see, and the court has to act on that, even if it doesn't come on the pink piece of paper, right, that the court is used to seeing as their petition. It provides clear decision-making standards for family members. It specifically protects the right to social interaction by limiting the situations under which a guardian can restrict a person's access to family and friends. Incredibly important. And it also facilitates restoration of rights, to go to one of the questions we had earlier today. So usually important for states to adopt the act. But adopting the act will go a tremendous way to improving guardianship in this country, but it's not alone enough. Changing the rules that courts must use will not by itself, without more, get us where we need to go. And to make that point, let's just consider for a moment some of the key stories that have been in the news around guardianship in the past couple of years. We have Britney Spears, right? Trauma with guardianship. She gave face to the high personal costs associated with guardianship. We had Michael Orr, who was the focus of the movie The Blind Side, revealing that he had, in his words, been duped into a conservatorship that had lasted for 20 years without court monitoring of any kind. Well, what do these cases have in common? I mean, many things, but when you look at the media coverage of these cases, the media coverage focused on bad guardians. Dad Spears, bad. The Tuohys, bad, right? And that may be the case. But in each of these cases, what was facilitating what was happening? It was courts, to be generous, asleep at the wheel, facilitating what was going on here. In the Spears case, we had a court that did not act on obvious signs that a guardianship was overbroad and unprotective, obvious concerns about the behavior of the guardian, taking the role that the court was more of a referee. But in a guardianship case, the court is not a referee. It is the state that is the party. It is the state that is acting on somebody by taking their rights. The court is not a passive player. And the court in the Spears case also didn't for a long time recognize her right to choose and hire her own counsel. In the Orr case, we had Tennessee law, the law in question here, prohibiting the imposition of a conservatorship unless a judge found by clear and convincing evidence that the individual for whom a conservatorship was being sought was disabled and needs assistance. Well, the court in Mr. Orr's case explicitly found that he was not disabled. Never found that he had a need for a conservatorship, and apparently never considered less restrictive alternatives either. The icing on the cake after appointing that conservatorship, creating that conservatorship, failed to monitor for 20 years. So I think the sheer wrongness of what the court did in the case may appear shocking, but the reality is that it's an open secret that courts routinely appoint guardians for people where it is not the less restrictive alternative, and that monitoring is anemic. So if we're going to make guardianship the less restrictive, protective option, it should have always been, we're going to need to look at court reform. So what is the evidence that we need court reform? Well, first, the lack of judicial compliance with existing state law. We know that most guardianships remain plenary, although all states They should be limited if at all possible. We know that due process protections are routinely waived. And we know that attorneys who go into court to try to represent someone who's seeking restoration of their rights often have their presence there challenged. What contributes to this noncompliance? Well, we could speculate till the cows come home, but a couple thoughts. One is that judges working in the space have minimal training. Many are rotating through these courts fairly rapidly without much training. We know that courts have inadequate resources devoted to monitoring in most cases. There's a lack of accountability. Thank you, 11th Amendment. And then the social acceptance of limiting the civil rights of older adults and people with disabilities. So let's talk about what's needed in terms of court reform. We need three things. We need improved training. We need improved management, and we need improved accountability. Very briefly, judges need to understand the legal standards they're being asked to apply. They need to understand how capacity is assessed. And they need to understand what are the less restrictive alternatives that might meet the needs of the people coming before me. In terms of improved management, we need improved management both of guardians through better court systems and better approaches for responding to complaints brought by family, friends, and the person subject to guardianship. In terms of improved accountability, we need legal standards that support the restoration of rights. Right now, in some states, it's sort of along the lines of, have you stopped beating your wife? Well, I was never beating my wife. Now I have to, right. Can you prove that you don't need the guardianship, right? And new legal tools are needed to facilitate restoration of rights. So look, this is almost always talked about as a state issue. This is a state law issue. But let me suggest to you that especially when it comes to court reform, this is also a federal issue. So we have this thing called the US Constitution. It has this thing called the 14th Amendment. And let's talk about it. When we deprive people of constitutional rights, and we do that without due process of law, it doesn't just violate our state statutes. It doesn't just violate, our sense of good public policy. It also is an issue of constitutional rights. It's a 14th Amendment violation. And think about the rights that routinely get denied through a guardianship. The right to marry, the right to procreate, the right to choose with whom you associate, the right to decide how, when, where you are going to practice your religion. Those are all fundamental constitutional rights. Congress could act, Congress should act, authorizing the Attorney General of the United States to bring claims in state court systems for injunctive relief to essentially undo guardianship orders, say, do it again, where guardianships restrict or strip these fundamental rights without due process of law, and authorize individuals to bring such claims. And if that was done with fee shifting, we would dramatically change the availability of people to do guardianship restoration work. So as we wrap up here, I just want to say, I think when we think about guardianship reform, it's really the time for action. We know what's wrong. We know ways we can fix it. The question is, do we demand that the legislative bodies in our country actually implement the changes? Because if we don't, we'll continue to get what we have today. A system designed to be protective, which for many individuals is the vehicle of their oppression. So on that cheery note, here is my contact information. It is a pleasure talking with you today.
So it's hard to follow up an act like that. And rightly so. I'm adding my thanks to everyone else, Sharona, and to the whole team here at Case Western Reserve, particularly Virginia Lefevre. You've been great. And Patty Harbold, who probably is just sleeping somewhere. She's probably just recovering from all of this. I also have to thank my photographer and car driver and research assistant, Noah Yegley. He came with me from Pennsylvania. And we've been working the whole way here. We've been working through meals, and we'll work all the way home, I suspect. I have to thank a woman named Hannah Dewhurst, and she is at the University of Pittsburgh. I'm going to talk a little bit about her. She shared some things with me that contributed to my talk today. And then finally, the students at my home institution, Penn State Dickinson Law, some of whom I think are online, including Alice Song, who is currently helping me on a filial support comparative article, comparing US and Germany and England and Pennsylvania with filial support laws that go back to the 1500s. Let me ask a quick question of our audience. How many of you are associated, would you say, primarily with law? Oh, quite a few. Well, we're in law school, that makes sense. How many are associated primarily with health? Okay, quite a few. How many are associated with social work? I know we have a lot of social workers. Good, very good. How many of you have had a loved one who experienced moments of some form of cognitive impairment that you are worried about? I thought that might be true, right? That's one reason why we're all here. A little bit of background for me, tiny print, but unimportant print, so it doesn't really matter. Is that I've been working in the area of law and aging since 1997, shortly after I moved to Pennsylvania from New Mexico, where I'd been teaching before. And I was a clinical professor at University of New Mexico, and I was asked to consider developing a clinic at what was in just Dickinson School of Law. It didn't join Penn State or have Penn State take us over, depending on your viewpoint, until later. And what might be a good area for another clinic? And I looked around and I realized we were right in the center of nursing homes, assisted living, continuing care, daycare programs. In other words, a whole lot of old people. And so I went to my first elder law program and I discovered the nicest attorneys I'd ever known. And they became my tribe. And so I slowly worked forward, learning more and more about it as I went in Pennsylvania. Eventually, I went from teaching doctrinal courses to having an elder protection clinic. When it was started, it was not an elder protection clinic. It was just a clinic for older adults who might need legal advice or legal representation. But over time, we began to realize that many of the very dynamics that were happening to our clients were the result of some form of predatory behavior, and sometimes because the client could not resist it. And a lot of it was just creditors hounding these people to death. They had no money, they were judgment proof, but the creditors would call every single day until we showed them how to stop that predatory behavior. So we eventually renamed the clinic the Elder Protection Clinic. And from there, I've done a variety of things. I've been lucky enough to travel internationally. And that's where social workers, that's where you're now part of my tribe. I'm part of your tribe as well, because I worked with a team of nurses and healthcare providers and lawyers and technology lawyers and social workers at Queen's University in Belfast on a project called the Changing Aging Partnership. And while I was there, I worked on the book that's about elder exploitation. And gosh, along the way, I ended up, we were talking about guardianship reform. One of the things I ended up on was the state Supreme Court's, Pennsylvania State Supreme Court's task force on elder justice. And it was brought together by the chief judge. She wasn't the chief justice at the time, but she became the chief justice while we were doing this long project. And she was really committed to a bunch of different reforms connected to older adults. So one of the ways I've learned is that you can change, the dynamic of guardianship law is if you have a leader at the courts doing that. And she was our leader. And it's gone on, it's an ongoing project. It's not perfect. Pennsylvania doesn't like to adopt new laws like Nina's law. We like to wait until laws have been around for a long time before we really trust them. And we just adopted Guardianship Reform Act 25 years ago. Why would we want to do another one quite so soon? But we'll get there. We'll get there. And I suspect with the help of people like Nina. I'm a co-author of an elder law prof blog. Lately, I haven't been doing as much as I used to. But one of the things that does is somewhat like my clinic, I'm constantly getting people writing to me about issues of concern. So I always get new issues. put this all together and I can say capacity is a theme that has continued to be part of my life in many ways. And the one I have at the bottom of the list is one that I share with you. I'm a daughter. Both of my parents ended up with cognitive impairment, either of an Alzheimer's type or vascular dementia. 3 of my 4 grandparents did as well. My sister and I have already reserved our room at the assisted living. No, this is not a joke, folks. No, we have a joint room at assisted living greenhouse project where we know we will eventually be. That is for people with cognitive impairment. We support that organization quite well. One of the reasons why I'm talking about this concept of lucid moments, which is my focus for today, is because I was at a continuing education program and a lawyer actually said to the lawyers in Pennsylvania, oh, make sure you understand how to establish that there was a lucid moment so your client who has dementia can still do that property transfer. It was like, wait a minute. I knew the case. It was a 1989 case. And I guess I need to do this. 1989 case, and it was one in which a son-in-law and a father went to the son-in-law's choice of an attorney on a Sunday to request documents transferring 2 pieces of property to the son-in-law. The son-in-law was actually a former son-in-law. His wife had passed away. The father-in-law's wife had passed away and they bonded. And the 2 pieces of property were a beach house in New Jersey and a house just outside of Philadelphia on the main line. So in other words, pretty expensive properties. And over the course of 2 Sunday mornings, about an hour one day and maybe another hour the other day, they did the property transfer. And the adult daughter in the family, there were several children still alive in the family, but the adult daughter was doing her regular cleaning at the house, the estate house, the home house. And she discovered the documents. And she knew her father wasn't doing well. And so, what eventually happened was a guardianship. And he was found to be profoundly compromised in the guardianship. And as a second step, she did seek to challenge those transfers. And 7 months later, despite the fact that at the guardianship, there was a finding of incapacity that was complete and total, and despite the fact that a psychiatrist had also evaluated him, but only 7 months later, said that he was deeply demented, the property transfers were upheld. And on many levels, there are reasons why that occurred. There were people who weren't very good witnesses in the room. But the reason that I began to be concerned was because of this notion of lucid moments. And here's what the court said. The Supreme Court, in upholding the transfers, said, the ultimate issue was not whether Weir was suffering from Alzheimer's disease at the time of the conveyance, or as testified to by the expert. Neither was it whether Weir had previously engaged in bizarre behavior as testified by other lay witnesses. One may accept those as facts and still conclude, as the trial court did, that Weir was competent at the time of the conveyances based on the evidence that although the disease caused him to be confused at times, it left him lucid at others. There is no necessary conflict in those 2 positions. The evidence that was credited by the court at the trial level and affirmed on appeal was testimony from the trial lawyer from those two interactions on Sundays. He testified that his client was oriented in time, place, and person. And that was about it. And the court said that was enough. And the court didn't like the other witnesses, including the daughter, and I could understand that. I was when I first read that case, I could say, well, that's 1985. But then when I went to that CLE and heard that this was being advocated as a continuing concept, recently, with help from my research assistant, we started looking for other cases. And so one of the cases we found is a 2019 case that talks about lucid intervals. And it says the lucid interval doctrine is only implicated when there is evidence that a testator is suffering from a mental illness Otherwise, the normal presumption in favor of testamentary capacity is operating. So in fact, anybody challenging capacity has the burden of proof. But you have this other little concept that if you can just establish, even if you've been shown to, have a distinct impairment, a distinct cognitive impairment, the other side can still win if they can show it was at a lucid moment. And that's something that concerns me as well. In the particular case, the Ware case that triggered all of my concern here, I had just come to Pennsylvania in 1995. I read the case for some other reason. And for whatever reason, I ended up calling one of the members of the family. I don't even remember who I called to ask through their attorney. Their attorney let me do this. And all I remember is the response. It was, I don't like lawyers, and that case destroyed our lives. Now, that wasn't the father, that wasn't the daughter, that wasn't the daughter who died. It was some of the members still living, talking about how that moment of lucidity finding really destroyed the whole family. Other cases that have had these kinds of lucid moments as standards to review, they go way back in Canada, 1800s. I'm hoping to do some more research in Canada. They are already challenging lucid moment standards for finding capacity in Canada. But Alabama, Oregon, I've got a case in Oregon that's very similar to the one that I was talking about in Pennsylvania. Alabama in 2011 said lucid moments are possible, but you didn't satisfy it here. So they would accept it if the right testimony was presented. And then in Louisiana last year, I found a case in which the court upheld powers of attorney that were granted during a lucid moment on the theory that that was better for the person. So we've been talking about best interest, substituted judgment, but here the court really said, that the appointment of a power of attorney was better for you, and you must have done it when you were lucid, and therefore it's better for you, and that's how it happened. Again, I can understand all of these cases, but what we also did is go through and look at what are the kinds of facts that influence whether there's going to be a finding of a lucid moment. And almost always the court says something like they were oriented in time, place, and person. And transactions affecting post-death transfers are often the subject. The ones that probably concern me more are transactions involving immediate transfers of assets, because those are the ones that can also impoverish the older adult, including those powers of attorney that could really make a difference in their lives, in their everyday life, not just their family's life. Transactions that often also contain allegations of undue influence. Transactions that are often providing something to a non-traditional beneficiary, which normally might expect to have a higher standard, but it ends up being a lower standard if you do it in this way. Transactions involving clear but conflicting evidence about both physical health and mental health. But the one thing that we often see in these transactions is it's the attorney's testimony who is the deciding factor. So it's the attorney who does the transactions, if there is one. A lot of times there won't be one, but if there is an attorney, the attorney who facilitates the transaction, if they say their client was oriented in time, place, and person, that often is the way in which the transaction is validated. Quite frankly, the ABA and the American Psychological Association have had concerns about that kind of testimony for a long time. So the APA and the ABA joined forces a number of years ago now, and they created 3 handbooks called Handbooks for Lawyers, Judges, and Healthcare Workers, I think it was called. And it's about assessment of older adults, but assessing in general, but for attorneys, judges, and other professionals. And they're good books. The APA will even let you download them for free. The American Bar Association will make you pay for it. And that might say something right there. But they're detailed. They don't give a checklist. They don't give a short tool. What they really want you to do is read the whole book and do a thorough interview. All things that probably should be done. I've never seen this book ever cited in an opinion where the issue was capacity. So I'm not sure who's reading it, but it's not the judges in the cases, at least not in a way that they cite. Another recent book that came out is The Assessing Capacities of Older Adults. And it's a case book, a study where individual cases are in the book. And so that is something that has triggered my next project that I'll say very quickly, which has been working with my students. I teach elder law now in modules. And I have a module on finance, I have a module on housing, I have a module on capacity, and I can teach up to 6 modules at this point. Each of them are shorter in time, 5 weeks instead of a 14-week, and they always do something practical as the result. And so I had students take some of the problems from the Assessing Capacities book, and often they're written from the standpoint of a health professional, and have them rewrite the problem or create their own problem from the standpoint of a lawyer. And I'm hoping that works. The papers are being written as I stand here. I hope anyway that that's what's happening. And then, and that's where the person I'm thanking, who I think is online, Hannah Dewhurst, she is a psychometrist at the University of Pittsburgh. And her brother happens to be a law student. That's how I discovered her. And she came in and she went through the kinds of testing that Dr. Barnes would have somebody do, I'm sure, in part of her studies, other people as well in the healthcare field. And she showed how they would be done. And at the end of the time, actually, it was so interesting. Some of the students said, I couldn't do those tests on the best day of my life. And she was, no, you just aren't focused. So she reassured them. But more importantly, what they said was, wait a minute. So if we don't have a standardized set of questions that we're asking as lawyers of clients, what are we doing? And we're saying, something that comes out with an answer. Do you know who you are? Do you know what city you're in? And do you know what year it is? Something like that, time, place, and person. And I think what the students realized listening to her, listening to the depth of what neuroscience is doing now in the year 2024 to evaluate cognition and all the different kinds of questions, including my most important questions about risk, ability to appreciate risk, to use judgment. She was telling why those are so important. And so I think the students really got it when they heard that from her. Pennsylvania and Cornell, they do have a tool that's called for short IDA. It's Cornell Penn Interview for Decisional Abilities, IDA, and it's assessment tool. I don't know of anybody who's been using it. That's part of my next research, is finding out more about that. But really what I'm asking all of you is your thoughts at this point. So sort of like, I have to say, Professor Wright, there must be something about us that both believe the audience should be helping us answer questions. You ask questions at the end as well. And really what I'm interested in is your reaction to this question. Should we as attorneys have better tools to assess capacity? I think the answer is probably yes. But I think the question also is, what are the risks of having anything that's called a tool? And how can we use them better? That's for my next phase of research. So I look forward to your guidance on all of that. Noah and I thank you very much. I'm sure that Hannah joins us in thanking you, and we look forward to your thoughts.
All right, folks, we have a little bit of time for some questions. Anybody has questions? We have a microphone here, and when I ask it, and another microphone over here, I ask you to actually speak into the microphone so the people who are listening in remotely will be able to hear you. First question, right here, Rebecca.
Thank you so much. That was such a great panel. I had a question for Nina about monitoring of guardianships. And you mentioned that monitoring is anemic quite often, and we have these examples where it just didn't happen. And I know that courts often blame lack of funding for clerks' offices to engage in more vigorous monitoring. I've often thought there's also an institutional design problem in that, a court clerk's office may be able to, at best, look for red flags in numbers, but is not really set up to evaluate the well-being of a person. And in light of that, I was wondering if you've given any thought to whether another approach might be to set up an independent administrative agency that engages in some kind of monitoring, or somehow take some of these functions that are non-judicial out of the court system.
Yeah, it's a great question. I'm not sure you have to take them out of the court system. You could. I mean, I think it's partly thinking about who is working in that court system. So you have one state that has essentially hired people with an accounting type background to look at this, much as we might look at recording tax information. And so that's within the court system, but with that, mentality of sort of more of a forensic approach, if you will. I don't think you need the fundamental change in who has authority or accountability to make that work. I mean, I think there's other things you can do in addition to that, although I think that approach is really good. I mean, I think the monitoring by families is critically important, right? I think it should be a strong default that families get information of these fundamental transactions. And then to facilitate court monitoring, requiring those guardianship plans is critical, so the court has something to look against. But yes, it's the people we have doing this don't necessarily have the training or the background to do it. I think there's actually a lot of ways to bring technology into this. I think part of the problem we have with court systems across the country is every court system wants their own technology system, right? I don't know why. I mean, I use Microsoft Word. People all around the country use Microsoft Word. It's not really a problem for me that other people use the same technological tools. But sometimes in our court systems, they want their own state system, and that becomes a barrier.
To be honest, I can say, I'm stunned at me saying this. Pennsylvania did this. Pennsylvania got on board, got a software package, refined it. It's in place. In the first year, I think they cracked over $1 million of assets that should have been reported, that hadn't been reported, and that they managed to track down. So it automatically began to be viewed as not paying for itself, but paying for safety. And it's but again, it's about leadership within the system. It's hard to impose it from the outside.
Question, we have one question here and then another question right over here next.
Has Professor Pearson seen interviews or the execution of a document that was videotaped? You have seen it. And
Are you talking about a specific instance of this?
specific instances and or from the other side, would you advise that practitioners videotape it if there's a question as to the competency of the party?
Yeah. I don't think I would necessarily think that's the solution. I think it's really knowing the client better and knowing them well enough to know that the transaction that you're dealing with is not a moment of lucidity, but actual lucidity, to talk about something where you said, I think actual was the word you used as well. And to be honest, I think a lot of attorneys who are elder law attorneys know this and they do this. But these kinds of transactions are by and large handled by non-elder law attorneys every day. And most of the cases I see where the lucid moment concept comes in, it's with, the casual relationship between an attorney and a client. And I think attorneys are kind of like normal people. They're result oriented and they're transaction oriented. They're being hired to do the transaction. The presumption is they're going to do the transaction. They're not hired to evaluate. And that's why one of the things I'm asking is whether we should have some type of a tool that's like an easier tool for lawyers to use if they are new to this concept. So they can at least follow a checklist of what to ask and why to ask, so that there aren't family members out there who are left with whatever the tragedy is when a bad plan has been put into place.
Thank you. Our next question.
Hello, I work with seniors, social work, and I have a 87-year-old client who drove herself to the bank through the main window and into the lobby. Okay. And she received a letter from the BMV saying that she had to do a medical, have her doctor file a medical form stating she was able to drive or not able to drive. Of course, she said she was not able to drive anymore. But I don't know who spearheaded that, because as of this time last year, when my father was driving into things, nothing like that this happened. We had to hide his keys and things like that. So I'm not sure if it's something new as of this year that the BMV is stepping up and taking away these licenses, because she had a certain amount of time she had for a doctor to fill it out before they would revoke her license.
Was this in Ohio?
Yes, it was Ohio, it was here.
Yes, so I don't know of anything new here. The police officer might have been particularly with it in that case, or perhaps the store owner contacted the BMV. I have seen with my own eyes cases where drivers did that multiple times because it was a store they liked and went into a lot. Yeah, that's a very individual case, and as you see, a different parent got very different treatment.
And by the way, my father, who did not have, who was already on the path of declining capacity, knew which of the DMV offices to go to. And he spoke a little Spanish and he was really charming, and he would go in there limping in and charm them right into that renewal of his life.
Okay, we have another question over here, and then our next question will be right back here.
So regarding like what you just, your comment, if a family member goes to the doctor or even a social worker in the hospital and says, I have concerns about my parent driving, there is a form, yeah, that we can do and send it to the BMV. So there is that. I don't know, I know we do it at Metro. I don't know about the other places, but I wanted to ask about driving also. If anyone is a mandated reporter and they have concerns that somebody is driving and that is dangerous to themselves or others, so regardless of like specific driving laws or whatever, but just being a mandated reporter, you should be calling that in, right?
You should be, but there's no protocol for what the DMV does with that information, because it's not controlled by law, so they can ignore it, they can act on it, they can lose it. I mean, it's just completely up in the air is the problem.
Right,
There's
so-
no system in place.
Okay, but from our end, that is still like something.
It's a good idea.
Okay. Even if nothing happens.
Wonderful question. Our next question over here.
Okay, so there are a couple of things. So in my world, taking away somebody's driver's license doesn't necessarily mean they're not going to drive. You know, they're very resourceful if they want to drive. You can take their car away. They might go to a dealership and get a new car. The dealership doesn't say, hey, are you a valid driver? If a family member takes the car away, they might call the police and say, my car's been stolen. So we've had that happen. And then just as a bit of information, our Cuyahoga County Probate Court does have a program called the Guardian Partner Program, and they do send out people to check on wards. It's just, it's an overwhelming job. There are thousands of guardianships and not enough people to do it. And they pay a small stipend, but they do try to get eyes on a guardianship, you know, every few years when they can.
We have a volunteer program in Pennsylvania. It's county by county, not every county has it. But where attorneys and anybody can volunteer to be a monitor of guardianships. And it's a very, you take training and you do it, and it's assisted in the integrity of the guardianship system.
Question over here. Another question.
I know of a situation where there's a bed-bound, wheelchair-bound 76-year-old who's very wealthy in a new guardianship, and the court paid attorney guardian has only visited once to him in a year and a half. Is that enough?
No.
Other questions? Other questions? So you have another question right here, right, same question from over here.
Who would you make a report to if you're like, do you call, like, who do you, I mean, you can't just call probate court.
Well, I mean, that's the issue. The individual that needs to be notified, the entity that needs to be notified of this is the court. And so a key part of the law reforms that I advocate for are rules that go into place so that when you call up the court and say, Joe Smith, my 76-year-old individual over here, has a guardian who is not paying attention to their needs and has X, Y, and Z problem, the court has to act on that, even though you have not filed official paperwork, right? And so that's a key portion actually of the Uniform Act, which I was discussing. It's a provision that would require courts, when notified of these problems with certain limitations, if you notify them every day, as some people will do, right? They don't have to act every day. But to require courts to act on that information and consider that information, even though it's not coming in the sort of formal legal process they're used to seeing.
That was what I was kind of asking before, like, that was kind of the same question.
Yeah, so I think the question being asked is, what do we do? And the answer is, notify the court.
Well, folks, we're just run out of time for this panel. Thank you so much to our panelists.